Holland Wilcox acknowledges the traditional custodians of the lands on which this podcast is recorded. We pay our respects to their elders, past and present, and to all First Nations people joining us today.
Hello, and welcome back to our latest private client podcast, Empowered Women, Wealth, Law and Legacy. This new series is all about empowering women to take control of their legal and financial futures. We've spoken about succession planning in episode 1 and financial planning in episode 2. Today, our focus shifts to asset protection and family law and how these issues are relevant to women. I'm really delighted to be joined by Chloe Rattray, a partner at Lander and Rogers, based in Melbourne, specialising in family and relationship law. Welcome, Chloe.
Thanks for having me, Juliet. I'm happy to be here.
Chloe, let's start with why we're having this conversation. Why is asset protection important from a family law perspective?
So in Australia, 1 in 3 marriages end in divorce. And in today's world, we know that relationships are complicated and so are the financial arrangements that come with them. Whether it's a couple's first home purchase with the assistance from their parents, a stake in a family business, or an unexpected inheritance, protecting those types of assets before entering into a serious relationship can save a lot of heartache and money down the track. And I also believe that this discussion is particularly important when directed at women. So whilst progress is definitely being made, I still see far too often women who have taken more of a back seat when it comes to understanding and managing their family's financial affairs. And this means that upon the breakdown of their relationship, which is obviously a highly stressful time in someone's life, it can be really overwhelming to need to then suddenly skill up in this area as well. Podcasts like this are wonderful. It hopefully really assists women, empowering women to be active participants in decisions that shape their future.
Thanks, Chloe. If asset protection isn't handled appropriately, what can happen?
Without proper asset protection, you run the risk of losing control over how your property is divided if a relationship breaks down. For many women who may not have been as involved in managing their family's finances, this can be particularly confronting. You could end up in the Federal Circuit and Family Court of Australia, leaving one of your major life decisions in the hands of a judge who doesn't know you, they don't know what's important to you, what your values are, and it's really a situation that just no one wants to be in.
So how can you protect your asset from a relationship breakdown?
The most effective way is through what we call a binding financial agreement, commonly referred to as a prenup or a BFA. And a BFA is essentially a contract which outlines what the property settlement outcome will be in the event of a separation. It remains completely inactive unless the parties actually separate. So for many people, it will sit in a top drawer somewhere and never even come into play. I like to refer to it as it just being another form of insurance. You hope you never need it, but it is certainly helpful in case you do.
Do you need to enter into a financial agreement at the start of the relationship?
No, not at all. So financial agreements can be entered into at the start, during, or even at the end of a de facto relationship or marriage. Currently, we're seeing a lot of high net wealth families or family offices prepare for their own transfer of wealth or family business from one generation to the other. Many of the matriarchs and patriarchs are insisting upon their sons and daughters all entering into similar financial agreements, which effectively quarantine future inheritances, as well as interests in family businesses and trust structures from forming part of the asset pool to be split between their children and their children's spouses in the event they separate.
It's so interesting and so relevant, Chloe, to many of the women we speak to every day in our practices. What arrangements can be covered in a financial agreement?
Yeah, in Australia, financial agreements can predominantly only deal with property, spousal maintenance, so what one party pays to another, and related matters. Property can include things like real property or houses, shares, cryptocurrency, money in bank accounts, vehicles, and superannuation. But it's important to note that it's only enforceable in relation to those assets located in Australia. So, for those relationships which straddle various countries or those couples who hold assets in several countries, we typically recommend entering into mirror agreements in the relevant country where possible so that they are adequately protected.
So, what happens if you've got a BFA and someone in the relationship dies?
A financial agreement only comes into effect if the relationship breaks down. So if one party passes away, it's of no use. Instead, the terms of their will come into play. And it's for this reason that we often advise our clients to consider preparing wills which reflect the terms of the agreement to cover all bases.
Yes, I certainly agree with you. Often, when we're assisting clients to prepare their wills, we have a discussion regarding their own entry into a binding financial agreement, not only for themselves, if one of them was to die and the survivor enters into a new relationship, but also for their children to enter a BFA with an existing or a future partner to protect the assets that the children may build up in their own relationships, but also the assets that they may be inheriting from their parents. So are financial agreements just for those with substantial assets?
No, that's far from the case. A common example of when we prepare financial agreements is often for the younger generation who may be purchasing their first home with the assistance of the bank of mum and dad, as I mentioned earlier. And whilst loan agreements can certainly be prepared, if they don't meet particular terms or they aren't properly complied with, for example, regular interest repayments being made, the family court can simply look through the agreement and view the loan instead as a gift to the parties rather than an amount owing back out of their asset pool to the people who loaned it to them in the first place.
We find that clients often believe that financial agreements aren't worth the paper that they're written on. What are your views, Chloe, in relation to those comments?
That's a really common misconception. So BFAs have faced criticism, especially after a well-known 2010 High Court decision in which a financial agreement was set aside. However, the reasons why that particular agreement was set aside were incredibly nuanced. Effectively, it came down to the fact that the woman entering into the agreement was placed under an immense amount of pressure, what the court referred to as undue influence and unconscionable conduct. And it's for that exact reason that I will never sign a client up to an agreement when they're getting close to their wedding date, or if they're, for example, about to have a baby. In those circumstances, I often recommend that we're just better off waiting until we get through this period so that the decision can be seen to have been made with clarity and confidence.
Right, so you're saying then that BFAs are enforceable.
Yes, absolutely. When they are done properly, they are enforceable. Because financial agreements aim to remove the court's role in deciding property settlements, the legal requirements around them are very strict. But in general terms, when both parties have independent legal advice, full disclosure of finances is made, and there's no pressure or imbalance of power, they are enforceable.
That's really good information to get out there because I know that there is an often misconception that they're not worth the paper they're written on. So it's good to have that reassurance. Yeah, I hear that many people say that they wouldn't enter into a financial agreement because their topic is just too uncomfortable to raise and that they aren't very romantic and they just prefer to put it off. Is this something that you hear?
Yes, all the time, and particularly from women. There's often a sense, I think, that raising the topic might rock the boat or seem untrusting. But the truth is, it's one of the most empowering conversations a woman can have. Yes, it's going to feel a little bit uncomfortable at first or awkward. I think any money conversation can be. But financial agreements are typically drafted to provide mutual protections. So, for example, if there is a carve out for future inheritance, well, that applies equally to both parties. And by way of another example, if one person's building a startup company and the agreement wants to quarantine out that company, well, it's great. It provides protection for the person whose business it is. But on the flip side, it also protects their partner from any financial risk if things don't quite go as planned with the business. So it's really about fairness, clarity, foresight, and it shouldn't be viewed with fear, in my opinion.
Yeah, good. That's reassuring. And I find that quite often when we're talking about BFAs, the advisor can give the clients comfort that it's something that we are dealing with more and more regularly. And once the conversation started, it's a lot easier to progress with it. And when parents come in to talk to us about their own succession planning, quite often they're very cautious about having to raise it with their children. But they're reassured when we can say, look, it's not something that you'll apply to one particular child. It may be a blanket requirement that, given the amount that the inheritance may be, it just makes sense for each of the children to consider this rather than to single out one of them.
Absolutely. For women who are planning to have children or whom already have children, a financial agreement can be a real gift. If the relationship breaks down, the agreement ensures the financial side is already sorted. So that means that both parents can focus on what truly matters for most parents out there, which is their co-parenting relationship and supporting their children through what can be a difficult transition. It's really about creating a space for emotional clarity when people need it most.
Thanks, Chloe. That's great advice. Look, so in closing today, who should be considering entering into a financial agreement?
Financial agreements are really for any woman or any person for that matter who wants to protect their financial future. They can be particularly useful or utilised by women entering a relationship with significantly more assets than their partner, women in second relationships who want to preserve wealth for their children, women who own businesses or share assets with others and want to shield those from relationship breakdowns, and women expecting significant inheritances or gifts from family members. Really, it's about having some control, certainty, and confidence in your future, whatever it may hold.
Thanks so much, Chloe. That's just so useful. And look, everyone, that's going to wrap up our episode 3. It's been a really interesting one and with lots of great information in there around BFAs. In our next and final episode, we're going to be joined by Lizzie Goldfinch, who's a partner and family office executive at Mutual Trust. Lizzie has worked with significant families and family businesses over many years to help them not only identify what's important to them, but also achieve those goals. She's got a really passionate interest in assisting women when it comes to managing their wealth and finding their purpose. So I hope you can join us then.
This podcast is not legal advice and should not be relied upon as such. You should always obtain legal advice about your specific circumstances.